Are you in pain? Then meet the doctor. Neck pain, headaches? Meet the doctor. Low back and leg pain? Meet the doctor. Arm, shoulder, and hand pain? Carpal tunnel syndrome? Meet the doctor. Injured in an auto accident? Meet Dr. James Bissland at Bissland Chiropractic, where you can get your first visit free this month. Call Bissland Chiropractic at 838-4252. Bissland Chiropractic.
Welcome to Chiropractic Health and Information. This is a half-hour program we're going to bring you once a month via our website to provide information for our patients, maybe other healthcare providers, and the general public. Since this is our first program, I'd kind of like to introduce myself, tell everybody who I am. I am a second-generation chiropractor. My father was a chiropractor, and I graduated from Palmer Chiropractic College in 1962. He practiced in Iowa, Oklahoma, and then in Florida. From about the age of 5, I decided that that's what I was going to do. I was going to be a chiropractor. And I told everybody that from the time I can remember. I remember kind of a funny story that my parents always told me is when I was about 3, Dad was just finishing his clinic rounds at Palmer, and they came out of the house and I was out there trying to adjust the dog. So that was kind of an interesting little story that they have, and they like to tell everybody that when we are out. But I did go on and become a chiropractor, graduated from Palmer College in Davenport, Iowa in October of 1985. And for about 9.5 years I practiced with my father in Florida. And that was a real big influence. I learned a lot of things about how to practice. I remember when I first got out of school, he told me, I'm going to tell you about all the mistakes I made so you don't have to make them again. So that was kind of a good start. And you know, there are a lot of multi-generation chiropractors that are friends of mine, and I think that makes it a lot easier for those of us who have family who are practicing and who have practiced, to be able to give us a lot more insight than going into it cold. As a chiropractor, the one thing that I find important, and again, another one of the things that my father drilled in me right when I graduated, is that we don't have a canned program for anybody. Everybody is a person. They need to be treated like a person, and they need to be given a treatment plan that's designed just for them, and nobody gets the same plan over and over and over again with the same people. And so with the help of him and some really fantastic practice consultants over the years, that 9.5 years I spent with him in Florida, we learned a tremendous amount of things about how to be good in the office, how to take care of patients, and how to take and put patients as a #1 priority. In 1995, my wife Lisa and I decided that we wanted to go somewhere else, and we came back to Tulsa, where I lived for about 6 years when I was in high school and early in college. And we came back here and have now been in Tulsa a little over 16 years, bringing up to where we are right now here. We're into June of 2011 as we sit and tape our program today. The purpose of why we're doing this is I want to have a forum that we can share what's going on in current healthcare and chiropractic events. We'll be taking some of them from our chiropractic magazines, things that are coming up. We're going to have a lot of legal issues that we'll be discussing on a regular basis. In just a few minutes, you'll get to meet our legal expert who will give us some good insight today and ongoing to be able to help get through some of the complications that happen in healthcare from a legal standpoint. Periodically, we'll be bringing in, having other doctors. We'll be interviewing other doctors as we go along to get some more information out about things that we can do, the methods that chiropractic uses, why we do what we do, how we do what we do. About once or twice a month here in the office, we do we call our special consultation. A lot of people will call it a patient lecture. But the benefit of that is we want everybody, when they start care with us, to be able to sit down and go through and have an understanding of what it is that we do. And we're going to explore that as we go through in the next several months of care. And we're going to explore a lot more of those topics as we go along each month in our program. And as always, to any of my patients in the clinic, but any of you, our viewers here now on our webpage, if you have any questions, you're always welcome to call us. We do a telephone consultation that we will sit down and we can talk about any conditions before you actually make an appointment or a commitment to come into the office. And I have had several people who felt really good about the ability to be able to talk about it, kind of make a connection before they make a commitment to come in. Also, in the next several months, as we move into getting further along with our program here, one of the things that we're going to do is, as we travel to different places and learn new things in seminars, we may be doing some of our segments from there, which will give us an opportunity to have some more experts in our field to join us to present a particular topic, from maybe some motivation, some positive thinking, some chiropractic, maybe even some additional legal information. It all depends on where we are and what we're doing and who's available. And one of the nice things is that we're able to pick on some of the brightest minds, I think, in our profession. So that kind of helps us to get a basic understanding. You know, one of the things that people are really misinformed about as a general rule about chiropractic, and that is they look at me when we go out to do a health fair. We go do the Tulsa State Fair, and we have a screening booth where we talk to people. We do postural analysis, we do spinal screenings, answer questions. And I have it kind of is funny in a lot of respects, because they'll say, well, I know I have a bad back and there's nothing anybody can do about it. And I like to ask questions, because questions just give you such an insight as to where their thinking is coming from. So I'll ask them a question. Well, where did you hear that? Well, my orthopedic surgeon said if I can have surgery, that's the only thing I can do. And I'll ask them, have you ever had a chiropractic evaluation? No, I don't believe in chiropractic. And I have a standard line for that, and a lot of people will laugh at it, and a lot of people do laugh at it. But my response to that statement is that we are not, as a profession, we are not a religion. So it works whether you believe it or not. And that's, they look at me kind of funny and they laugh. They think I'm joking. Sometimes I am, but most of the time I'm not. Because what we are is a healthcare field. I've never heard anybody tell me that they don't take aspirin because they don't believe in aspirin. You either take it or you don't. It's very simple. One of the things that people are confused about is that they look at us and say, well, you're chiropractors, you're bone doctors. We work with the spine, which is obviously bone. We work with the joints, which are obviously bone. But in all reality, if you look at what we do and what we work with, it's the nerves, and it's the nervous system. The nervous system is the master of everything. Everything in our body is controlled 100% by the nervous system, which is the brain, the spinal cord, and the nerves that come from the spinal cord out to the rest of your body. And those are the things that we're going to be exploring each month. We're going to pick a different topic, and we're going to talk about that topic and how it relates to chiropractic. Before we go to our first break, I'd like to introduce our guest tonight. He's also going to be our legal advisor and provide legal information for us for this program. And I'd like to welcome Lloyd Benedict from the Benedict Law Office. Lloyd, welcome.
All right, thank you, Dr. Bissland. It's an honor for me to be here and be able to be part of your first presentation. I look forward to this and possibly maybe doing some things in the future. Earlier before this tonight, you'd asked me a few questions, a couple of items to focus on, and a couple of those are going to be really on some of the hot topics of some of the laws that have changed affecting personal injury patients, and more specifically personal injury patients who are maybe senior citizens, ones who might be receiving Medicare or even Medicaid. And there's a lot of things that have happened since then, and we'll talk about that here in just a second.
Okay, now Lloyd, you've been in practice now here in Tulsa for how long?
I've been in practice since 2004, but I've been involved in the personal injury practice since 1988. First as a paralegal, up till the time I decided that I could probably make a difference as a lawyer when I attended law school in the year 2000 and graduated 2004 and been practicing personal injury since. But the whole time it's been involved in the personal injury arena.
So you deal with the car accidents, the slips and falls, the work comp.
Anything that requires a Band-Aid, I'll focus my practice in those areas. Absolutely.
Okay. When we come back, we're going to have a discussion and all about the Medicare and Medicaid ramifications if you're involved in an auto accident, and we'll be right back after this.
Where were you when the lights went out? Who did you call and when you gave them a shout? Did they pick up the phone? Did you get a machine or some front office drone? You know what I mean. You want to talk to somebody who knows what they're talking about. So call Marie now. Electricians with a mission will get you connected with Marie Electric.
Hi, this is Larry Murray with Murray Electric. We appreciate your business and we don't take you for granted. While nobody likes to have electrical problems, we want you to know that we will be here for you when you do need an electrician. And remember, you don't get phone shuffle when you call Murray Electric, because we have a real live electrician that answers the telephone. Remember, if you're in a hurry, call Murray, 918-835-9605. 918-835-9605.
We'll get you connected with Marie Electric.
Are you in pain? Then meet the doctor. Neck pain, headaches? Meet the doctor. Low back and leg pain? Meet the doctor. Arm, shoulder, and hand pain? Carpal tunnel syndrome? Meet the doctor. Injured in an auto accident? Meet Dr. James Bissland at Bissland Chiropractic, where you can get your first visit free this month. Call Bissland Chiropractic at 838-4252. Bissland Chiropractic.
Welcome back to Chiropractic Health and Information. As we were saying before the break, Lloyd Benedict from the Benedict Law Office here in Tulsa, Oklahoma is going to basically give us an overview for the next 10 minutes or so of the requirements for dealing with an auto accident, especially if you're Medicare and or Medicaid. Following his presentation, we're going to end the program today with about a 5-minute video that he's prepared, which basically gives you a lot of information about auto accidents in general. So, Lloyd?
Dr. Bissland, thank you again. There's a lot of facets of things that happen in personal injury cases, and each and every angle of it can be a difficult process, no matter whether you're a Medicare recipient or beneficiary or just a young individual, a young adult. But as time go on, things become a little bit more complicated. Laws change, and again, our more current political environment, there's been a lot of changes in the law. And in the advent, and since the last year, Section 111 is a new law that I'm going to talk here a little bit about and kind of give you some familiarity. And you might really pay a little bit more attention to it, especially if you're a person who's 62 and a half years or older, and even more specifically if you're 65. And the reason why at 62 and a half years of age is important because Section 111, the new law that it requires insurance companies to report all injuries of people that are 62 and a half years or older to Medicare. And in a sense, that's what Section 111 is. It's It's really Big Brother's way of looking into your personal life to see if you're going to be getting money for an injury, and then turning around to Medicare and asking Medicare to pay for those same visits to the doctor. So it's more of an information gathering law rather than anything else. Another component of it, of course, is Medicare is trying to have some accountability. Should they pay for some treatment that is related to a, let's say, doctor bill that is incurred because of your injuries? You get injured in a car accident, you have to go see a doctor, you're a Medicare beneficiary, and Medicare pays the bill. Well, Medicare would want to know that who the insurance company is that you're dealing with, and at some point get reimbursed back for anything that the government pays for that accident-related treatment. So let me analyze that a little bit further, and that's just kind of the summary, but let me go into a little bit more detail on that. Section 111, again, is a law that requires insurance companies to report all settlements to Medicare, and they are required for anyone who's 62 and a half years of age. Now, if you'll note, 62 and a half years of age, you're not actually receiving a Medicare benefit. You will at 65. But what they're wanting to do is get some early reporting in the event that a person has a serious injury from an automobile accident or a fall injury of some sort, something that you'll be maybe settling or getting a court award on for that injury due to somebody's negligence. But at 62 and a half years of age, Medicare wants to know what's happening before you become a beneficiary, so when you become a beneficiary, they may opt not to pay for anything that is related due to somebody else's negligence, or something that you may recover from a settlement or court award anytime before 65 years of age, but after 62 and a half. That way, they'll have an accounting there, and when you go to a doctor, let's say now you're 66 years of age and you had an accident when you're 63, Medicare could say, well, wait a minute, Mr. Johnson, I see had a back injury when you're 63 years of age, and you settled for a large sum of money, but now you're asking for Medicare to go ahead and pay for that same back injury. Well, not so fast, Mr. Johnson. What we're going to do is we're going to make you prove what money you received from that personal injury case, and we're going to ask you to apply that money that you put in your pocket from that personal injury case to pay for your own medical bills related to that back injury that you had that Medicare did not pay. Well, that's what they call a set-off approach. That's the concept of maybe the Section 111 as applies to people that are 62 and a half years of age. People that are 65 years of age when they're injured due to somebody else's negligence, again, whether it's an automobile accident or a slip and fall injury at Walmart where Walmart negligently left some water on the floor, some example like that. When you're 65 years of age and you obtain some treatment, that could be chiropractic treatment or your primary care physician or maybe an ambulance ride to the hospital for whatever the injuries may be. If Medicare pays that, again, the insurance company gets a report when the injured person sets up a claim with the insurance company. Then they are required by law to send or contact Medicare to say, hey, Mr. Johnson has been injured in an accident and we may or may not be settling with him, but we're doing our duty to report that. Well, then the burden gets passed on to Mr. Johnson. Mr. Johnson then has to contact Medicare, and he has to report, hey, I was in an accident last week, and I went to a doctor, and I'm dealing with an insurance company, the person who caused the injury. Say, for example, it might be State Farm. And hopefully, State Farm is going to be paying me, reimburse me for my medical bills, and for my lost wages and pain and suffering and mental anguish and permanency and loss of use and permanent impairment and disfigurement and whatever else Mr. Johnson can prove that he might be entitled to receive from the other insurance company based on the evidence at hand. Well, this information that Mr. Johnson reports to Medicare, then they'll send a letter out to him and say, well, now we need to get some more clarification. We need to get the claim numbers of the insurance company you're dealing with. If you have medical payment coverage with your own insurance company, well, we need to get that information too. And we need to learn a little bit more about your injuries. We need to learn who you're treating with. And if you have a lawyer, we need to know that information as well. So Mr. Johnson will be required to go ahead and get that information to Medicare. Medicare then in turns, one of two things will happen. It'll go actually in a two-branch approach. One branch is that Mr. Johnson actually treats with a physician, and that physician gets paid by Medicare. That physician makes a claim to Medicare, and Medicare pays him for injuries related to that accident. The other path is that Mr. Johnson goes to a physician, and that physician does not get paid by Medicare for whatever the reason may be. So we have these two different Y approaches here. Under the first approach, where Medicare has paid something for his accident-related treatment, well, at some point during the case, when Mr. Johnson tries to settle with the insurance company, and if you recall, I exampled State Farm, so if Mr. Johnson tries to settle with State Farm's going to say, well, did any of your bills get paid by Medicare? And Mr. Johnson would have to say yes, they did or did not, and show proof of it. Well, that insurance company probably won't issue a settlement check if Medicare has paid something to Mr. Johnson's bills until Mr. Johnson can prove how much Medicare paid. So there is that process by itself is going to really require the person to be involved in the case, to get a little bit more information, to go to Medicare and to get this information. Meantime, it can slow down the entire process by months. So the key is to get in there early enough to get set up with Medicare and to have that system in place, so by the time you're released from the physician, everything's ready to go and you're ready to get the case settled. I highly recommend that you consult with a lawyer if that situation ever arises, as with any personal injury case. That pretty much wraps up Medicare. I can go on for hours and talk about it.
I'm sure you can. In fact, I remember a day you did. Well, we got about a minute and a half here, and then we're going to talk about a little video. But if somebody has an accident, they are a Medicare beneficiary. First thing they need to do is obviously get to the doctor to find out what injuries they have. Second thing they do is call you.
The second thing is to contact a lawyer before they even call the insurance company, to learn at least the strategy of what to do or what not to do. Whether they want to retain an attorney or not, they should at least know what their rights are.
And I'm assuming that you have people that call you all the time.
It's a never-ending struggle to be out there and educate the public, and people are just curious sometimes. Well, they may not feel a need to retain an attorney, but what they need to realize is when you're injured by somebody else's negligence, it is a legal matter from the get-go. You're going to be dealing with an insurance company or highly trained professionals, and even have their own legal staff. So a person who doesn't have a lawyer going into a personal injury case is a little disadvantaged to try to deal with it themselves.
Yeah, well, the insurance company obviously has their experts.
That's what they're trained to do, and they're trained to not pay money out. That's
and they're trained very well at that.
They do. That's how they have these billion-dollar corporations.
Well, Lloyd, tell us a little bit. We got a video of that Lloyd has put together that we're going to end the program with today. Tell us a little about the video.
The video I designed really to kind of get to folks that really want to get some information of what to do. They've been involved in some type of accident, they don't know where to go, and they don't know what they should do or what they shouldn't do or what their rights may be. And so really it's a 5-minute video, very informative and very easy to follow, and anyone ever has any questions that watches this, I'll be glad to further answer their questions. But it really tells you the things to do and not what to do with the insurance company as it comes to giving certain information or not signing certain records, or what your rights may be, what the big picture is, and how evidence works. For example, you have to prove pain and suffering. There's no presumption. You don't take your medical bill and multiply it by a magic figure. It actually has to be proven, and everybody may have that proof, and some people may not have that proof. Okay. So it's a good example of what that DVD is about.
Okay. Well, we're going to end the program with that video, and if you have any questions, we will have on the screen here Lloyd's contact information will be put up there. We're going to be back with you next month. Look first around the first part of August for the August version of Chiropractic Health and Information. Until then, have a good month, and may your life be healthy and accident-free.
Hello, I'm Lloyd Benedict, and for the next few minutes I'd like to discuss how I evaluate personal injury cases. As a personal injury lawyer, one of the most frequent questions I am asked is, when am I entitled to recover? In the state of Oklahoma, injury victims may be entitled to recover money for damages. Damages may include items like medical bills, lost income, pain and suffering, mental anguish, permanency, and disfigurement. Another question I'm frequently asked is, what is my case worth? Simply put, your case is worth whatever a jury decides. However, most cases can be settled if an insurance company can be persuaded to settle. In order to settle a case, you must understand a few basic things about insurance companies. You do not have a legal right for settlement. It's all a matter of persuasion. Insurance companies do not make profits by giving away money. The other person's insurance company does not represent you. You have the burden of proof to prove your damages, not the insurance company. Anything that the insurance company asks or tells you mostly benefits them. And lastly, they do not personally care about you or your circumstances. The next question then becomes, how do you persuade an insurance company to settle out of court? Insurance companies, like juries, require evidence to prove that your damages are reasonable. For example, if you're in a motor vehicle accident and you're injured, you're required to be seen by a physician. A physician may charge you, let's say, $150. In turn, you give that bill for the $150 to the insurance company, and they'll probably consider it to be reasonable, and you'll probably settle your case for a fair amount. Well, what happens when your medical bills are $2,500 or even $5,000? Well, rest assured, it's going to require additional evidence to prove that that treatment was reasonable and necessary in order to receive a fair settlement. At Benedict Law Office, you can trust that I'll obtain all the evidence necessary in order to prove your case to the insurance company and receive the maximum settlement amount. The first stage is investigation. Careful investigation is necessary to understand all the facts of your case, understand the nature and extent of your injuries, and identify all the people responsible for your injuries. Investigation also requires obtaining all evidence that supports your damages, including required evidence of pain and suffering. Such evidence will give your case the extra strength needed to make winning arguments that leads to maximum settlements. Simply put, the more evidence and the more people that can be held responsible for your injuries, the better your settlement possibilities. The second stage is evaluation. After all the evidence has been gathered and all the responsible parties have been identified, I can then carefully examine the evidence to determine whether certain evidence will be considered strong or weak by the insurance companies. This is a critical stage because this is where the case strategy is developed. That is to say, it is very important to predict how the insurance companies will consider such evidence. The third stage is negotiation. Successful negotiation for me begins with my presenting the insurance company with the strongest and most effective evidence I was able to obtain. Such evidence allows me to control the negotiation process instead of the insurance company. Because I have negotiated over 15,000 personal injury cases since 1988, that experience allows me to obtain the maximum settlement for any particular case. The result is, I'm able to settle the vast majority of my clients' injury cases in the shortest period of time. If that case does not settle, then the next stage is litigation. In some instances, insurance companies want to delay the case by making lowball settlement offers that are inconsistent with the evidence. This requires the filing of a lawsuit. Despite lawsuits taking considerable time to finalize, my experience allows me to settle most of the lawsuits without even having to go to trial. Many of my clients contact me soon after an accident has occurred. By doing so allows me to develop a case strategy necessary in order for me to effectively handle the case. However, there are many people that delay contacting an attorney only to find out that the insurance company has taken control of their case. To avoid harming your case, you should consider the following steps. Do not allow evidence of your accident scene to disappear. Do not allow evidence of your visible injuries to disappear. Do not give an insurance company a recorded statement. Do not use the insurance company's suggested body shop to fix your car. Do not give the other person's insurance company a signed medical release. Do not delay getting proper medical care. And do not miss your scheduled medical appointments. Whether or not you intend to hire an attorney, I strongly encourage you to contact me personally so we may discuss the strengths and weaknesses of your case and what your rights are. And remember, contact an attorney after you've been duped from an insurance company may be too late to solve the problem. Well, I'm Lloyd Benedict, and again, thank you for your time.